Section 4, Legal Hotline, Q&A. Part 1, Today's Fair Housing Rules and Regulations, 2026 Standard. Introduction, from recognizing discrimination to making the right call. In the last section, we focused on how discrimination actually shows up in today's market, subtle, disguised, and often hidden behind everyday decisions. We talked about steering, misrepresentation, lending bias, and even harassment. But here's the reality: recognizing discrimination is only half the battle. The next step, the part that defines you as a professional, is what you do in the moment when faced with a decision. That's where the legal hotline comes in. This section is designed to simulate real-time situations where agents must decide quickly, often without perfect information, and with real legal consequences on the line. In 2026, these are not hypothetical situations, they are daily occurrences. One misstep can lead to a complaint, litigation, or disciplinary action. So now we move from awareness to application. What does compliance actually look like in real life? Understanding the pressure of real-time decisions. Picture yourself in a transaction. A client asks you something that feels off. Maybe it's about who should live in a property. Maybe it's about what should be disclosed. Maybe it's about rejecting an offer for reasons that don't sit right. These are not black and white moments. They are gray areas where your knowledge of fair housing laws is tested. The Fair Housing Act applies broadly to anyone involved in housing, including agents, landlords, lenders, and even municipalities. It prohibits discrimination based on race, color, religion, sex, national origin, familial status, and disability. But as we saw in the last section, discrimination today is often indirect. That means your role is not just to avoid obvious violations, but to identify risks hidden in everyday practices. Scenario 1. Registered sex offender. Knowing the limits of protection. Let's start with a situation that often creates confusion. You're representing a tenant and discover they are a registered sex offender. You feel uncomfortable continuing the relationship. The question becomes, are you allowed to terminate? The answer is yes. A registered sex offender is not a protected class under fair housing laws. This ties directly back to our last section. Understanding discrimination requires knowing who is protected and who is not. Not all decisions that feel uncomfortable are illegal, but misunderstanding this line can lead to overcorrection or unnecessary liability. Scenario 2. Age-restricted housing versus disability protections. Now let's build on the concept of protected classes. A buyer wants to purchase in a 55-plus community but has a disabled child who must live with them. The HOA wants to enforce its age restriction. At first glance, this might seem straightforward. Age-restricted communities can limit children. But as we learned earlier, disability is a protected class, and reasonable accommodations must be made. Courts have ruled that refusing to allow a disabled child to live with their family may violate fair housing laws. This is a perfect example of how modern discrimination works, not through obvious denial, but through rigid enforcement of rules that fail to account for protected rights. Scenario 3. Buyer letters. When good intentions create risk. Let's go back to a common situation in today's market: multiple offers. Sellers often want to know more about the buyers, and agents may be tempted to request letters of introduction. But as we discussed in the last section, discrimination often happens when protected information is introduced into decision-making. These letters frequently reveal race, religion, family status, or national origin. Once that information is available, even unintentionally, it can influence the seller's decision. Because of this, best practice in 2026 is clear: avoid requesting or encouraging these letters. The safest path is to keep the transaction focused strictly on the terms of the offer. Scenario 4. Reasonable accommodation, parking for a disabled tenant. Now let's revisit disability discrimination, one of the most commonly misunderstood areas. A tenant with a mobility impairment requests a reserved parking space near their unit. The property has a first-come, first-served policy and no reserved spaces. As we discussed previously, policies that appear neutral can still create discriminatory outcomes. In this case, the landlord must make a reasonable accommodation and provide the reserved space. This ties directly back to the idea that discrimination is not always about intent, it's about impact. If a policy limits access for a protected class, it must be adjusted. Scenario 5. Religion includes non-religion. Let's take another subtle example. A seller wants to avoid selling to atheists and asks you to reflect that in marketing. At first, this might seem like a personal preference. But under fair housing laws, religion is a protected class, and that includes individuals who do not practice religion. Atheists are protected, and advertising in this way would be a violation. This reinforces an important point from the last section. Discrimination today often comes from assumptions, not intent. Scenario 6. Disclosure and gray areas. Finally, let's look at one of the most complex areas: disclosure. You are listing a property near a group home for troubled teenagers. The seller asks if this must be disclosed. The answer depends on whether those individuals are considered to have a disability under the law. If they are, disclosing could be discriminatory. If they are not, disclosure may be required. This is where fair housing intersects with other legal obligations, and where professional judgment and often legal advice is necessary. Bringing it all together, the agent's role in 2026. If Section 3 taught us how to recognize discrimination, this section teaches us how to respond. Every scenario we covered is rooted in the same principle. Fair housing compliance is not just about knowing the law, it's about applying it in real time, under pressure, with incomplete information. In 2026, agents are expected to identify potential discrimination before it happens, make legally sound decisions quickly, educate clients when their requests cross the line, document actions to protect themselves and their brokerage. This is the difference between an average agent and a professional who operates at a high level of compliance and integrity. Online discussion. Question 1. Why are buyer letters considered risky in today's market? Answer: because they may reveal protected class information, which could influence a seller's decision and lead to discrimination. Question 2. How does reasonable accommodation apply to housing policies? Answer: policies must be adjusted when necessary to allow a person with a disability equal access to housing. Question 3. Why is it important to understand protected versus non-protected classes? Answer: because fair housing laws only prohibit discrimination against protected classes, and misunderstanding this can lead to improper decisions.